Hey there, I'm estate planning attorney Paul Rabelais, and in this video I am going to explain the estate planning choices that you have that go along with the right or responsibility that you have to look after the well-being of your kids and grandkids. The options that you take advantage of may depend on many factors: your children's age, their financial maturity level, the value of your estate, their marital status, along with your specific feelings about the whole purpose behind an inheritance. So I'm breaking this down into 5 different areas of protection, and with each area I'll share with you your options so that you can make informed decisions moving forward. First, let's start with the fact that your children might be minors. Now, I don't have any more minor children. My 5 kids range in age from 30 down to 21, but for a parent with minor children, it can be unimaginable to think that a parent may pass away due to illness or injury and that someone else may have to raise your children. So this first protection that we put in place for parents with young children is to designate in your last will and testament who will be your minor children's legal guardian if you pass away before your children reach adult age. Fortunately, as parents, you get to decide who will have those parental rights so that in your last will and testament, you can designate the appropriate legal guardian who shares your parental values and has that natural ability to provide loving comfort and emotional stability. It's a big decision, and it's one of the most important reasons parents with minor children should put their estate legal affairs in order, even though the actuarial tables say that you have a life expectancy of several decades. The second protection you should consider putting in place for your children and grandchildren, if you feel it's necessary or helpful, is to eliminate the option of them getting a lump sum inheritance that they could blow by setting up your estate plan so that the inheritance of your descendants goes in a trust when you pass away. While some parents say, "Paul, let them have it. If they blow it, it's their fault." Others feel better providing that their descendants will inherit over time, unable to blow it all at once. In this second protection of providing a trust for an inheritance to prevent mismanagement and overspending, you would designate someone to be the trustee of the trust, and you, in your estate documents, would provide direction regarding when your child or grandchild may receive distributions. You have several options regarding the when your children or grandchildren could receive their inheritance after you pass away. You could provide that they'll receive it at a certain age, for example, age 25. And if you pass away before that descendant is 25, you could provide that the trustee would be authorized to make distributions to or for the beneficiary for their health, education, maintenance, and support, even before they reach 25. But the beneficiary receive what's left at that determined age. Many parents like the idea of leaving an inheritance to children or grandchildren in stages. For example, you could say that the beneficiary would receive 1/3 of their inheritance when they reach the age of 25, 1/2 of the remainder at age 30, and the balance at age 35. Again, you could give the trustee discretion to use the inheritance for the beneficiary's health, education, maintenance, and support before those stated ages. Another option is to give it to them in stages, with each stage being a certain number of years after you pass away. For example, they could get 1/4 as soon as practical after you pass away, 1/3 of what's left 5 years after that, 1/2 of what's left 5 years after that, and the rest 5 years later. So that works out to about 4 equal distributions. So if they screw up the first one, they still get 3 more chunks. And then one other when do they get it decision involves giving the trustee that you designate the discretion to determine when your children or grandchildren get their inheritance. This might be appropriate if, for example, you have a child or grandchild and you have no idea when they will be ready to manage an inheritance the right way. So you give that trustee the discretion to determine when your child or grandchild can have the inheritance. The third protection that you may consider putting in place is the protections necessary to protect the inheritance so that it is for your child only and not their spouse, even if your child gets married and divorced 1 or more times. There may be nothing worse for a parent to work and save their entire lifetime only to leave an inheritance to their child and then to have their child divorce and lose half of it to their ex-spouse. Making an inheritance divorce-proof for your child typically involves leaving their inheritance to them in a trust so that the inheritance of the child does not get commingled with other assets that the child owns jointly with their spouse. The fourth protection may seem counterintuitive, but some parents feel that you're not doing your children and grandchild any favors by leaving them a large inheritance. Some parents feel that leaving a large inheritance for their children and grandchildren may squash the ambition and hard work ethic that people need to accomplish great things with their lives. If you feel this way, then giving it to them over time is a start, but you may also consider actually limiting the amounts that are set aside for your children and grandchildren at your death and providing more for charities or other causes that you know can make your community or this world a better place. The result of this strategy may be leave this world a better place than you found it, and you won't have to worry that a large inheritance will adversely affect your children's or grandchildren's drive and life choices. In addition, as a side note, we often see children in estate planning want to do something similar to what their parents did. So you may be starting something here that could last for generations. And fifth and finally, your estate planning decisions can protect your descendants through the designations that you make as your executors, successor trustees of your living trust, power of attorney agents, and healthcare decision makers. You see, each family has its own dynamics based on the relationships of all family members. You can protect all of your descendants by making these decisions of who handles your money and who talks to your doctors. And by making those decisions, you will also indirectly be making decisions of who won't be involved in that. So those designations of the right people, whether that is one person or two or more making decisions together, are important decisions when trying to protect your descendants. Now it's your turn. In the comments below, what's the first thing that comes to your mind when considering the concept of protecting your children and grandchildren from an estate planning perspective? I look forward to reading those comments of yours. Have a great day.